All right, good afternoon, everyone. It's a pleasure to have you all here with us. So I'll just introduce myself. My name is Amr Kode. I'm a professor here at the Faculty of Law. As well with me is Professor Kenny Grad, who helped me co-organize this talk for today. So what I'm going to start off with is our land acknowledgement. I'm going to just talk a bit about our lecture series and situate this talk within that, talk a bit about the professors who started the series in the first place, and then I'm going to go about introducing our distinguished lecturer for today. So let me first start with the University of Manitoba campuses are located on the original lands of the Anishinaabe, Ininiwak, Assininuak, Dakota, Oyate, and Dene peoples, and on the national homeland of the Red River Métis. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to moving forwards in partnership with Indigenous communities in a spirit of reconciliation and collaboration. So welcome everyone to the 15th DeLloyd J. Guth Visiting Lecture in Legal History. I'll just say a few words about my colleague, Dr. Guth, who is now retired and living comfortably in Ann Arbor. Dr. Guth began teaching here at Robson Hall in the late 1980s and retired roughly December 2018. He was a specialist, of course, in legal history, particularly British legal history. He taught our Canadian legal history course for numerous years. He also taught comparative law and our first year legal systems course. As part of that course, we have a program called Judge Shadowing. So first year students attend at the court and shadow judges, as it suggests, and learn things in close proximity to them. So he was a significant part of that program. And about a decade and a half ago, he started this lecture series, which bears his name, with our inaugural lecture being the Honorable and then Chief Justice of Canada, Beverly McLaughlin, who talked about Louis Riel. And since that time, we've had numerous eminent scholars who've joined and leading up to our distinguished guest today. And so thanks to the generous endowment that Dr. Guth and his wife created, so since his retirement, we've been able to continue these lecture series on a go-forward basis. So he's not here with us today in his retirement, but thanks to the video recording that we're going to be doing, he gets to enjoy it from the comfort of his own home. So just a special thank you to Dr. Guth for helping us continue this lecture series. So now on to our speaker today. So I'm just going to do a brief introduction and let him take it away. So Dr. Eric M. Adams is a professor of law at the University of Alberta. He graduated with an LLB from Dalhousie University and SJD, which is the equivalent of PhD equivalent in law at the University of Toronto. He's published widely on various topics, including constitutional law, human rights law, legal history, and legal education. He's won numerous awards. I'm not going to go into all of them because it's quite eminent. But in relation to his research, he's published quite a bit in the area of Japanese-Canadian internment in Canada. And his current work that he's, I think, completing is on the exile of Japanese Canadians following the Second World War. So that's the subject of our talk today. So he'll be speaking for roughly 30 to 40 minutes is the idea, and then it's going to be followed by a question and answer session. So just as a note, as you see the camera behind over there, the lecture portion is going to be recorded, but the Q&A we're going to be shutting off so that we can have more of a freewheeling conversation after, if that's the case. Okay, so without further delay then, please join me in welcoming Dr. Eric Adams.
Well, thanks everybody, and thanks Amr for that nice introduction. Just because I believe in lowering expectations, when I told my students this week that I had to cancel class because I was giving a lecture somewhere else, they cheered. So that's how fun it is to spend an hour in my company. But let's see if I can do better than that today. My thanks again, as I say, to Professor Kode and Professor Grad for organizing this event. It's really an honor for me to participate in a lecture series named after one of the pioneers in Canadian legal history and to join the list of outstanding lecturers that have already been at this university. The story of Exile that I want to talk about today is at its heart a story about place and belonging. And so I wanted to begin by noting my own place and belonging to this place, to Winnipeg. It's a second home for me, so I'm so pleased that a number of my friends and family are in the room today. When I told them about this lecture, they said, "Will pizza be served?" And that seemed to seal the deal, so that was good. Before I was an legal academic, before I worked in a law firm, I worked for the YWCA of Camp Stevens. My first boss is in the room. You can ask him if you wish about the time he sprung me from the clutches of the Winnipeg police. I was innocent, but enough of that. But it was at the Winnipeg Y that some of the people in this room and I grappled with, I think, really important questions. How do we live together well? And that is the story of Canadian constitutional law. It's the story I've been trying to think about for my entire career. And it's a story that finds a massive failure in the story of Exile. So in 1946, after the Second World War had ended, Canada exiled 3,964 Canadians of Japanese descent to Japan, a mass banishment on the basis of race. The history of that exile matters, I think, as I'll argue today, and it should matter more than it has to the Canadian legal community in particular. For the exile, like so much of the harms committed against Japanese Canadians during and after the Second World War, is a story of law and the failings of that law. But for some of the people in this room, it's not just legal history, it's personal history, it's family history. Some of the people in this room have experienced these harms firsthand, but everybody's family in the Japanese Canadian community has felt the impacts of this history. There are a number of leaders from the Winnipeg Japanese Canadian community here, friends that I've been working with for many years, in research partnerships to tell this story from different perspectives. But in particular, I wanted to recognize Mr. Art Mickey. As many will know, Art led the National Association of Japanese Canadians in the redress movement that achieved an official apology from the Government of Canada for some of these wrongs. He's been a tireless advocate of anti-racism and in keeping this history alive in the many decades since. So I just wonder if you'd join me in recognizing Art Mickey, who's here today. Art's one of my heroes. Finally, I want to acknowledge that this work emerges out of a project called Landscapes of Injustice and also Past Wrong, Future Choices, both large research grants funded by SSHRC very generously to try and tell this history from as many perspectives as possible. And I'm happy to speak about those projects, but if you're at all interested in knowing more about this history, I'd urge you to Google Landscapes of Injustice and to follow the work of that extraordinary research partnership. The research leader of that partnership is Professor Jordan Stanger-Ross. He's a historian at the University of Victoria. And it's with Jordan that I have just completed the first draft of our book on the exile. So before books look like real books with covers, they look like 310 pages of Word document. So that's what this book is. And this work with Jordan forms the basis of the research that I'll talk about today. And I hope it looks more like a book about a year from now. That's the plan. Okay, I want to start this talk in a strange place. In June 2018, the United States Supreme Court delivered its divided opinion in Trump and Hawaii, a decision upholding the legality of President Trump's executive order, which banned foreign nationals from a number of majority Muslim countries from entering the United States. Why we would wish to return to that history is beyond me. I hope it remains history and not current politics, but enough of that. This particular decision involved a disagreement on the court about the function of the Constitution in relation to racism, but a point of commonality regarding an important case in American constitutional law, Korematsu and the United States. Korematsu, as virtually every American law student learns when they go to law school because they read it, and it's assigned first-year reading in their first-year curriculum, Korematsu upheld President Roosevelt's executive orders incarcerating Japanese Americans on the basis of their race during the Second World War. Korematsu is part of what American academics call the legal anti-canon, judgments famous for their wrongness, for their moral and legal repugnancy. Korematsu has formed a part of nearly every American's legal education since it was decided. As the American constitutional scholar Jamal Green has written, cases like Korematsu help map out the landmines of the American constitutional order. They tell us what we are not. In the majority judgment penned by Chief Justice Roberts in Trump and Hawaii, he determined that Korematsu was irrelevant in deciding the legal issue before him. Nonetheless, Chief Justice Roberts wrote, in response to the dissent, that it is time to make express what is already obvious. Korematsu was gravely wrong the day it was decided, he wrote. It has been overruled in the court of history and, to be clear, has no place in law under the Constitution. For Justice Sotomayor, in dissent, Korematsu remained all too alive, including for what she called was the barren invocation of national security to justify racial discrimination. She did, however, agree with the majority that the formal repudiation of a shameful precedent is laudable and long overdue. In Canada, we have no equivalent of Korematsu, no wartime case that every law student reads, no repudiated legal history that every lawyer knows, no story that historians grapple with involving the wrongs committed against Japanese Canadians as a matter of law. Or at least we think we don't. In Canada, we tend to approach this story as a history of politics, not law. The Politics of Racism is the famous title of Anne Sunahara's excellent book on this topic. And of course, she's not wrong. The politics were racist. But a focus on politics has a way of letting the law and the legal community off the hook. And it has allowed us to forget and overlook the role of lawyers who worked at every stage of the development, implementation, and sanction of the unconscionable human rights abuses leveled against Canadians of Japanese descent, including the Exile. This, I think, is how many Canadians do think about this history. And it's a quote I draw from Andrew Coyne in a column he wrote a year or so ago, in which he made reference to, quote, the brief failure of our collective moral compass during the wartime internment of Japanese Canadians. I think Canadians, if asked, would say that they know that there was a brief moral failing and a wartime internment of Japanese Canadians. I think many would describe the history in similar terms. But this sense of the history is wrong in many ways. The mistreatment of Japanese Canadians was deliberate, sustained, multifaceted, and enduring. It was not, in any sense, brief. Internment lasted 7 years. When you think about 7 years, you think about, in the context of your own life, the span of an entire childhood or a university career, of professional training. Internment lasted longer after the Second World War ended than during the war itself. Not long ago, I attended a conference. Come on in, don't worry. Not long ago, I attended a conference on the American incarceration of Japanese Americans. And before the panel was about to begin, the American sitting next to me turned to me and said, "I can only imagine nothing like this happened in Canada." And I said, "You're exactly right. What we did in Canada was a much, much worse." And at that point, his face kind of furrowed because that wasn't the answer he was expecting. And at that point, I'd also exhausted his interest in Canada. So we both just turned and looked forward. But I think Canadians have been influenced by that sense of the American history, that internment is the story. But Canada's story is different than that. Internment occurred, yes, but it was just the start of a cascade of policies that inflicted far deeper harms. So in Canada, unlike the United States, after the uprooting of Japanese Canadians from coastal British Columbia, the government made the decision to seize all of the property that Japanese Canadians had been forced to leave behind. That did not occur in the United States. When that initial seizure took place, which, by the way, the Canadian government asked Japanese Canadians to cooperate with by listing all of their assets and property so that it could be carefully collated by government officials, the government promised Japanese Canadians that that property would be returned when the war ended. That is not what happened. In January of 1943, the government reversed course and decided that the better course of action was to sell all of the property that it had seized. Every home, every personal possession, every automobile, every tool, every article of clothing, all of it was sold at government auctions, leaving literally a people without homes. From that placelessness, from that destruction of home, the policy of exile seemed a natural follow-through. Let me say something about Winnipeg. On May 21st, 1946, a tragic scene played out at the Winnipeg train station. 92 Japanese Canadians, adults and children who had been living in Winnipeg and rural Manitoba, boarded CNR trains bound for Vancouver. As they boarded, many wept. 98% of us don't want to go at all, said one young man to a reporter. Many of the families were being broken apart in this moment. Parents being separated from children, children from parents, siblings from one another. One of the young girls boarding the train, being sent to Japan, worried what would become of her when she got there. I can neither speak nor write Japanese, she worried. Families had come to the Winnipeg train station bringing food for their long journey, sacks of flour and sugar. Canadian officials told them none of that food would be allowed on board. It had to be all left behind. 7 RCMP officers guarded the journey because the passengers would not be allowed to step off that train lest they changed their mind until they were placed on a ship bound for Japan. Many families never saw one another again. We don't have images of that day in Winnipeg beyond that story in the Winnipeg Free Press, but we do have pictures from similar departures at train stations in the interior of British Columbia through the spring of 1946. And these images are often mislabeled in archives, and indeed it was not the fault of this university, were mislabeled in the first version of the poster for this talk because many people think that these are images of internment, of 1942, of Canadians being rounded up and placed in internment camps. That's not what these pictures are about. The war has ended. It's 1946. And these are pictures of Japanese Canadians saying goodbye to their friends and their relatives as some 3,000 are being exiled to Japan. This is a haunting image of, in some ways, the two faces of this exile. Parents protected their children through this process as best they could. And for some kids, they can remember it as having moments of excitement. But you can see the weight of this moment on the mom's face. The unknowns of the journey ahead, of the loss of home that she was going to carry with her. It was kind of a controlled chaos. But at the center of it all, and you can see in this image, Corporal Davidson. I haven't been able, despite many years of trying, to discover his first name. But Corporal Davidson was literally at the center of this photo, but at the center of the RCMP's role in the Exile. He's a figure that we'll return to later, and we'll see him throughout this story. But here he is organizing Exile on the train platform in the interior British Columbia in 1946. How do we get here? How do we get to a moment when thousands of Canadians are being torn from the country, torn from one another, and stripped of their citizenship? How can we be there after the war has ended? What kind of failings must have taken place to get us to these train platforms? It's a story that is deeply braided with law. Law is at the origins of this story and will remain a story of law throughout. It begins with the invocation of the War Measures Act in 1939, emergency legislation that transfers lawmaking power from Parliament to the Cabinet. After the War Measures Act is invoked, because of the onset of the Second World War, it's now Cabinet that possesses the power to make law, executive orders that will have the force of law. And they make those orders in the thousands in the years to come. Hundreds of those orders involve and focus on Japanese Canadians. The first ominous signs of those orders begin with registration, and this is before the war with Japan and Canada even begins. In 1941, early in 1941, executive orders require that all Japanese members of the Japanese race register with the RCMP and carry identification cards with them at all times. This is the registration card of Lily Yano. But the most fateful of these decisions occurs in February of 1942 when the Government of Canada elects the policy of total uprooting on the basis of race. They had alternatives and considered them. And people within government advocated that total uprooting was not necessary. You might, for example, simply have moved Japanese nationals. You might have moved military-age men. You might have treated Japanese Canadians the same way that the Government of Canada was treating German Canadians and Italian Canadians, both of ethnic communities with which Canada was engaged internationally in similar respects. But those decisions were rejected. What was announced then was a total racial uprooting. Every woman and child and man would be taken from their homes and first placed here in a clearinghouse in Hastings Park in Vancouver. Some of you will know it, where families stayed sometimes for days, sometimes for weeks and months before decisions were made about what internment facilities they would be fanned out to. And if not internment facilities, then work camps on Canadian highways, sugar beet farms in Alberta and Manitoba, or if families could afford to do so, they could move to Eastern Canada under their own finances. When Canada uprooted those 22,000 people from coastal British Columbia, it had a problem: what to do with the property. The first seizures were of the fishing boats owned by Japanese Canadians for their livelihood. But fishing boats were the start, but not the end. The homes, the farms, the businesses, everyday possessions, precious family heirlooms, all of it was taken in the months to follow. To give you some sense of the scale of just the boats, you can see the thousands of seized fishing boats. And as I say, within 6 months after the seizure had been completed, the policy changed to advocate for the forced sale of all of those items. This again took place not at the level of simply possessions, but also the businesses that Japanese Canadians had in some cases built over generations. And so you could see signs like this one in Vancouver in 1942 of people celebrating a change in ownership. And in this period, you will not avoid the explicit language of whiteness, that it is white people who are going to be protected by this policy. It is white people that need the draconian measures imposed for their own good, and it's white people that will get the benefit of the seizure of these and sale of these properties. For the Government of Canada, dispossession, internment were bureaucratic matters run out of the Vancouver office of the custodian of enemy property. And you don't often see images like this, but I think it's important for lawyers to see them because of the way that these look like lawyers' offices doing the work of normal government bureaucracy, filing and collating and keeping track of everything that is being taken. And when we think about the loss of those communities, I think it's important to think about that when property is taken, it destroys more than the connection to the item. It destroys the community that are sustained by those connections to home and place. So all across British Columbia were vibrant Japanese Canadian communities, despite the racism that the community endured from the early days of immigration late in the 19th century. But they were families and community centers and language schools and Buddhist temples and life. That was all to be destroyed. What would a government do with a people that it had interned and then destroyed a sense of home? It began to occur to government officials that maybe exile was an answer to a problem that the government itself had created. Maybe exile would be a way to treat a people who literally had no place in Canada to go. Maybe exile would be a solution to the racism that Canada had been enduring. And so in 1945, the government wondered how might it convince as many Japanese Canadians as possible to accept exile to Japan. And again, our government records display just how thoroughly they debated alternatives. Could they simply send disloyal Japanese Canadians? That wouldn't work. How could you test loyalty? Could they simply send Japanese nationals back to Japan? Well, that didn't work because less than a third of the population of Japanese Canadians remain Japanese nationals. Too many Japanese Canadians would remain under that system. What about encouraging Japanese Canadians to accept exile to Japan? The government landed on that policy objective, but they knew it wouldn't be enough simply to ask Japanese Canadians if they were willing to accept exile. They had to create the conditions to get the answer to be yes. And so they did in a process called Signing Day, in which the Canadian officials and RCMP officers in particular fanned out to internment camps, but not just internment camps, because every Japanese Canadian living in Canada, no matter if they were in Hamilton or Halifax or Roblin, Manitoba, were tracked down, found, knocked on the door, and presented with a form. There were only two choices: sign or refuse to sign. Refusing to sign meant staying in Canada. But signing, which was encouraged and was framed as the cooperative thing to do, meant that you were accepting exile to Japan at the end of the war. Alongside the RCMP, the man in charge of this endeavor as the administrator was Tom Pickersgill, a Winnipegger, and the younger brother, some historians may know the name Pickersgill, Jack Pickersgill, was a leading advisor to Prime Minister Mackenzie King. So a famous Winnipeg family, and a younger brother Tom is put in charge of the exile program. Pickersgill goes to internment camps in particular, and they know that it's in internment camps that they'll have their best success in encouraging internment. Although when they knock on the doors of small-town Ontario, some people are willing to accept exile, most are not. But internment camps, they know they have cards to play. So what are those cards? Well, first they insist that if anyone in an internment camp refuses to sign for exile, they must immediately leave that internment camp. And internment camps are when many people had been living for, at that point, 3 years, often with employment. The job would disappear immediately, and you would need to leave the internment camp for Eastern Ontario immediately. So many Japanese Canadians did not like that bargain. That wasn't in their best interest, especially when they asked Pickersgill, what will happen if we do get forced into Eastern Canada? And here is what Tom Pickersgill told them in the notes that he recorded of his successes in these internment community meetings. So after he got back from meeting with internees, he wrote down the questions they asked him and the answers he gave. Sensible questions from sensible people. What would life be like for us in Eastern Canada? Tom Pickersgill records his answer that he cannot say. Will we be allowed free movement and mobility once the war ends? Tom Pickersgill, I can't say. Will people relocating to Eastern Canada have full-fledged rights as Canadian citizens? So in this period, Japanese Canadians are not allowed to vote. They've been banned from the franchise from 1878 on. Tom Pickersgill says that he cannot say. This is a poignant one for a parent because Japanese Canadians wanted to know about the prospects of their children's education. Tom Pickersgill gives the worst version of the Canadian constitutional answer that that's a provincial responsibility. But in any event, he cannot say. It's not very surprising then that given this system, in some internment camps, over 90% of Japanese Canadians signed for exile, and overall the internment level was at over 70%. In total, over 10,000 Japanese Canadians sign exile forms, many of them on the understanding, they say, that it was assured to them that they could change their mind in the future. This is all before the end of the Second World War. So in the fall of 1945, or the summer of 1945. Of course, in August of 1945, the United States drops 2 atomic weapons on Japan. The war ends, and the country is devastated. Devastated by a collapsed government, devastated by atomic bombs, devastated by famine and mass starvation. Many Japanese Canadians in the thousands say, we want to make good on the assurance that we could not be forced into exile despite the fact we signed those forms. We no longer wish to go to Japan. And it was at this point that the government of Canada entered its orders of exile in December of 1945. And we see now how signing day is reframed as disloyalty. So for the orders of exile, having signed was to show your allegiance to an enemy country and that you were unfit for permanent residence of Canada, which meant in the orders of exile that anyone who had signed those forms could now be compelled by law to exile, whether that person had changed their mind or not. It's a little more complicated because there was a provision of the orders which said that if you were a Canadian-born citizen, you could stop your exile prior to receiving the orders of which ship you were being sent on, but everyone else were forced to go. That's how this issue ends up here in the Supreme Court of Canada. Is this legal? Could you force people into exile after the war has ended? Could you strip their citizenship? Could you tear people from a country that they had known as home? The exile case is monumental for many reasons, but one of them, alongside of everything I've said, is this. In the 1930s, the Supreme Court of Canada needed a new courthouse. Swarms of moths were eating the books. There were rats in the basement. The judges said, this building is too hot. Other judges said, this building is too cold. So some things never change about Canadian judges, I guess. That's what we know there. But it's the Depression, and the government says the judges can wait. Eventually, the Minister of Public Health condemns the Supreme Court of Canada as an unfit workplace. And it's then that a new Supreme Court of Canada building begins to be built on Wellington Street, overlooking the Ottawa River. But war, as in many things, alters plans for the building. So the government said after the building was complete, we need this for war work. And so the Supreme Court of Canada was for 5 years taken over by government officials. But in January 1946, even though the Federal Tax Department would still not leave the main floor, the Supreme Court of Canada insisted that it was time that they get their new courthouse. The first case heard on the 24th of January 1946 was reference re-persons of the Japanese race. Were the orders of exile lawful? Now I say reference case because the government had decided after passing the orders of exile that it could not wait for these laws to be challenged by individual Japanese Canadians, which Japanese Canadians had already said they were going to do. It would be better, the government said, to simply send this case to a reference case to ask the question of the Supreme Court of Canada, was this legal? Let's get the question quickly. The government was immensely confident in the answer, and hearing the case would be these 7 white judges. Law students will be very excited to hear that the case of these 7 judges was issued in 5 different opinions. Every law student's dream judicial opinion. And you have to read all of them to understand the overlapping reasons and what the court, in fact, held. I will summarize it for you this way. The majority of the court, or at least one majority of the court, found that the exile was lawful in almost all of its respects. Canada could banish anyone they wished on the basis of race, even after war ended, as long as the government decided that it was necessary to do so. Chief Justice Rinfret, for that majority, found that the government was well within its rights to determine that Japanese Canadians, having signed exile forms, were, quote, a menace to Canada. Nonetheless, a different group of judges, writing a different aspect of what became the majority reasons, split on a narrow point. They said that the orders compelled the exile of wives and children under 16, even if those wives and children had not consented to the exile. That, said this majority of the judgment, the law could not do, because there was no rational security rationale for doing so. So the exile was upheld for the most part, but limited to the extent that wives and children who had not signed their own forms, and most women had signed their own forms, so this was not a large number of people that this covered, could not be exiled. That ensured an appeal to then this place, the Judicial Committee of the Privy Council, still Canada's highest court of appeal in 1946. Supreme Court of Canada is not supreme until 1949. So the appeal went to London on the issue of what about these exile orders were legal or which portions of them were not. It was a panel decided by 5 law lords and 1 retired Supreme Court of Canada judge, Sir Lyman Poole Duff, who had just retired as Chief Justice of the Supreme Court, was now hearing his final case as a member of the Privy Council. The Privy Council also included Lords Wright and Simon, two famous British judges and legal figures of the period, and two judges deeply associated with upholding Britain's executive orders on detention during the Second World War. Lord Wright, before the Exile case, about a month or so before the case was heard, he wrote to his friend Lord Simon and said this: "In wartime, it is absolutely necessary that the executive should be given considerable power, just as soldiers have to march in step and obey orders without question." Lord Simon wrote back and agreed, confiding that he did not think it was wise, quote, "to draw a strict line of legal division between persons who are naturalized and persons who are natural-born citizens of the country. Both," he argued, "could be extremely dangerous." Lord Simon, during the First World War, had written the British executive orders authorizing the detention of dangerous persons. So in Britain, Lord Simon recused himself and refused to listen to any or hear any of the British wartime detention cases. He says, "I can't, I have a conflict of interest. I wrote the laws that are being questioned." The Canadian Exile case, he felt no conflict about and sits. In a decision released in December 1946, a decision written by Lord Wright, the Privy Council upholds in its entirety all of the exile orders. Lord Wright says, "There is nothing the executive cannot do under the War Measures Act that it deems necessary, including exiling people on the basis of their race." Why don't we read this case? Why isn't this our Korematsu? Why isn't this a legal story that we care about in law school? Why is it not part of our anti-canon? Why these silences around exile? Well, among the many reasons, I think, are the nature of the decision itself. Do not go home and try and read this decision. It is not a good time. It is a reference case that turns on dry statutory interpretation and technical rules about executive orders of government. Missing from the case entirely is anything about signing day or even Japanese Canadians and their experience of the war. The names of Japanese Canadians do not appear in this decision, and their experiences of war are also absent. The Exile case ignored Japanese Canadians, and legal history has ignored the Exile case. And we're hoping that our book addresses both silences. I'm wrapping up, but I wanted to just speak a little about who does get exiled. Even though the government had won the exile case at the Judicial Committee, it did not take long for the government to step back and decided that it did not need to, in fact, carry out all of those compelled exiles of more than 10,000 people. One of the reasons it decided that was that it had already exiled almost 4,000. During 1946, while these cases are being argued, government took the position that even though the legal question of the exile orders was being litigated, there was nothing stopping the government from giving people free passage to Japan if they wished. This they called the purely voluntary exile. And so 5 sailings took place out of Vancouver, one of them on Christmas Eve, 1946. That is Tom Pickersgill, and that is Corporal Davidson. Seeing the culmination of their work, they attended the pier to see the exiles off. The Japanese Canadians that arrived in Japan felt immense hardship. I've already spoken about the conditions of the country, and I won't belabor it, but many struggled in those conditions, and many sought to return to Canada. The government put many bureaucratic obstacles in their way. We do know that many people over the course of the next several decades returned to Canada, but we also know that many thousands did not. Somewhat remarkably, to my mind, Japanese Canadians, despite these legal failings and failures, felt hope in this country, felt hope in what our Constitution might provide them, even against evidence to the contrary. It was a belief that there still could be justice in Canada. This is what the Liberal government said after exile had been completed in 1947. History will record, a Liberal cabinet minister argued in the House of Commons. History will record that in light of the desperate situation that existed in this country in 1942, the policy of relocation of the Japanese race was carried out in a humane way. It was in the best interest of the country. There was no breakdown in law or order. It was in the interests of the Japanese themselves. They will thank this Parliament for the policies which were set in motion. I think history has a different story to tell. So thank you very much.
Thank you very much, Eric. I think we'll, of course, open it up to questions, comments. All right, well, I think you spent a lot of time answering a lot of questions, and we thank you for that. So, on behalf of everyone in the room and the law school in general, we want to thank you very much for this enlightening talk. I have to say, listening to the story, but having the visuals was really striking along the way. So thank you for that presentation. And as a sign of our token appreciation.